If you have exercised or pretended to be entitled to exercise any of the privileges of membership in the bar of this court, when you are not, in fact, entitled to exercise such privileges, you may be additionally referred to the Standing Committee on Professional Conduct for possible sanctions for unauthorized practice of law.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Let's get started in the Eastern District of North Carolina, Western Division. So Eastern District of North Carolina, Western Division. So we're in the east half of the state, but the west half of the east half of the state. So shouldn't that be like the third quarter? So this is 3 cases here, and you might recognize the Steve Sands name because he was the name of one of the previous Liebowitz lawsuits that we covered just last week, I think it was. This is another one of those. These matters are assigned to the undersigned judge, where each plaintiff appears through Richard P. Liebowitz Esquire, comes now before the court of its own, that's the court's own initiative, so of its own initiative, attorneys in good standing of the bar of a United States court and the bar of the highest court of any state may practice in this court for a particular case in association with a member of the bar of this court. This is a really awkward way of saying that you can enter a court for one case only if you are not a member of that court's bar. If you're not admitted to that court, you can be admitted for this time only. It's called pro hoc vice. We're going to talk about it in a little bit for the Northern District of California because he's also screwed up there. But here in the Eastern Division of the Eastern District, Western Division of North Carolina, it appears Mr. Liebowitz's standing has been called into question in the United States District Court for the Southern District of New York, referred to as a copyright troll in a case involving one of the plaintiffs named above, Steve Sands. A district judge recently observed Mr. Liebowitz has been sanctioned, reprimanded, and advised to clean up his act by other judges of this court, referring to New York. Serious sanctions were imposed by the judge in that case on account of plaintiff's discovery deficiencies, including requirement that Mr. Liebowitz personally pay defendants' fees associated with advancing its motion to dismiss as a sanction for alleged discovery misconduct. This judge joins the chorus of those telling this attorney to clean up his act. The dockets of each of the cases assigned to me wherein this attorney represents a plaintiff are littered with deficiency notices. This is a harbinger for troubled litigation ahead. Hence, I wore my oh heck hat today for you. In Matthew Bradley, which is one of the 3 cases, initiated by complaint filed by Mr. Liebowitz, he was noticed right away to file a notice of appearance. It took over 2 months for him to bring himself into compliance. In Steve Sands, similarly, he was noticed of numerous deficiencies at the case's start. This includes these 3 notices of deficiency. 1, the plaintiff must pay the civil filing fee, which can be paid by cash, check, or credit card at the clerk's office during regular business hours. Or you can use pay.gov, which is an additional credit card option as long as you're willing to pay the credit card fee. Also, he did not include a civil cover sheet. There's a simple cover sheet that allows the court to quickly categorize cases, and he did not file those. And it says, it even tells him what electronic event he should be using. Use notice other. That even shows up there. And counsel did not properly identify themselves. Attachments must be clearly labeled. Exhibit A is not a sufficient description, so he didn't describe one of his attachments. There was another notice of deficiency in Steve Sands. Out-of-state counsel must comply with the local rule for pro hoc vice. The same notice was repeated August 27th and disregarded by the attorney. This court had to issue an order nearly 2 months after the opening of the case, expressly drawing this deficiency to Mr. Liebowitz's attention. If no appearance is made by the stated deadline of October 10th, Absent some showing of good cause, this case will be dismissed. And when was this filed? This was October 10th. In Alessandro Massi, filed September 30th, just a few days ago, a number of deficiencies immediately were noted by the clerk. Counsel did not properly identify exhibits. When filing a document, use the proper description. Counsel needs to file a notice of appearance, a financial disclosure form, the policies and procedures manual regarding refiling of the complaint, okay, notice of deficiency of payment, and the fact that he filed it in the Eastern Division when it should have been in the Western Division. So these are all basic competency things. And remember, Richard Liebowitz is filing thousands of cases. I believe it was like 1,110 cases or something in 2 years he had filed, and he was planning on filing many more. There is a Rule 1.1. In fact, this is important enough to bring up. Model Rules of Professional Conduct 1.1. Just search MRPC 1.1. and you'll get the American Bar Association's Model Rules of Professional Conduct. These are not the rules. This is the source of the rules, though. So each state implements some version of the ABA's Model Rules of Professional Conduct. This one, the rule of competence, is not going to be too different from state to state. Rule 1.1, competence. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. This is one of those rules where if you can think of a way it's been violated, that's probably a violation. If a lawyer should have known what the law was, if a lawyer should have looked up what the rules were before filing a case, if a lawyer forgot to follow Civil Rule 5.2a, if they forgot to follow Civil Rule 7.3, 7.1, there's also one for the entry of appearance, 83.1. If they forgot to follow all of that, at some point, maybe not one mistake, maybe not even 2 or 3 mistakes, but at some point, a mistake is large enough or numerous enough that you are not within your duty of competency. The duty of competency is not something that happens to you. You make it happen. If someone calls me and says, Leonard French, can you handle a patent case? Well, I'm allowed to take a patent case. No one's going to physically step into my home office here and say, no, Mr. French, you didn't study patent law. You can't take a patent case. That's not going to happen. No one's even going to know that I'm being proposed a patent case and I'm thinking of taking a patent case even though I'm not experienced in patent law. The only people who know because of the lawyer-client privilege are the lawyer and the client and anyone the client has told, because the lawyer is not supposed to tell anybody. So if I take a patent case, me, Leonard French, who is not competent to take a patent case, I could become competent. I'm allowed to go take patent courses or even just self-study until I feel that I am competent enough to take a patent case. Now, there's an extra problem with my hypothetical. There is also a patent examination. I have to take the patent bar in order to represent people before the Patent Trial and Review Board, PTAB, is it? I'm not competent to do it in the first place, is what I'm trying to get at, is that there's a duty of competency. And so for Liebowitz to not follow the rules at some point implicates his duty of competency. The problems described above appear rooted in a failure to read or understand the court's CMECF policies and procedures manual and the court's local civil rules, and are disrespect for the work of the clerk. There appears a failure to profit from the clerk's work to bring issues to the attorney's prompt attention. I think that's what that means. I think this is an extra attention in here that shouldn't be there. But here's the thing I wanted to point out. You've got several sets of rules. So I feel bad for myself as an attorney and a little bit for Richard Liebowitz, not for him in this situation. He's caused this himself by filing too many cases and not being able to be competent in every one of them. What I'm trying to get at here is that there are lots of rules that attorneys have to follow. Oh, well, there's lots of rules. Well, let me go over some of these rules. You have the substantive law. So Liebowitz needs to know copyright law since he's filing copyright cases. He needs to know the copyright law at the federal level. He needs to know how the court in North Carolina treats copyright law. He needs to know the federal rules of civil procedure. He needs to know the federal rules of evidence. He needs to know the local rules for the for the Eastern District of North Carolina, Western Division. He needs to know the rules for the judges, the judge that he's individually in front of. So if he's filed 2 or 3 cases here and he's before, in this case, it's the same judge, but if he was before 2 or 3 different judges, he would have to know 2 or 3 different judges' rules. And he has to know the CMECF procedures, the Case Management Electronic Case Filing Policies and Procedures Manual as well. So he's got to know, what is that, like 6 sets of rules? And I'm not even talking about like, oh, I'm going to look up the rule, it's only 1 page long or something. He needs to know 6 substantial bodies of law and rule and procedure in order to do all of this, which is why he shouldn't be able to just walk into North Carolina court, file a bunch of cases without having entered his appearance pro hoc vice, which is for this time only. Pro hoc vice is also usually limited to a certain number of cases per year. Many districts say that you can't pro hoc vice into more than 3 cases per year without some kind of really good cause or something. And if you need to pro hoc vice into more than 3 cases a year, just use local counsel and have them do all the work. And I don't know. I find that to be an access to justice issue. If I want to represent people in North Carolina and I'm a Pennsylvania attorney, but I'm competent in copyright law and my client wants me because I'm competent and known in copyright law, wouldn't it be an access to justice issue if the judge said, no, you must hire a local North Carolina attorney and you must not hire Leonard French because he's not allowed to pro hoc vice into any more cases this year? That sounds like an access to justice and freedom of association issue. I can understand a little bit the protectionism of wanting a local attorney to represent, but that also drives costs up, and driving costs up drives defendants away. It drives them into settling cases instead of fighting cases because they can't afford to hire 2 attorneys if they can't find a local attorney that satisfies them. Many of these issues repeat themselves from case to case. See also AdLife Marketing and Communications Company versus Carly C's Operations Center, including a deficiency notice concerning failure to pay the filing fee, identify attachments, proposed summons and civil cover sheet, failure to associate local counsel, failure to file financial disclosure statements, and they have all been brought to counsel's attention more than once with no remedial action. This attorney is on notice that he has until October 10th, 2019 to cure any and every deficiency noted in this case, in these 3 cases. If no address is made in accordance with these orders, the cases will be dismissed. And that was the 4th day of October, even though this is being docketed on the 10th day of October. So can you look up, Tactical, while I'm continuing with the story, can you look up whether he actually did file all that stuff by October 10th in these 3 cases? On October 10th, they received the filing fee. Here, I'll copy paste. So this is what it actually looks like. So this is Bradley versus Analytical Grammar, which is one of the Flanagan cases that we're talking about here. On October 10th, they suddenly got the filing fee. 2 months later, on October 10th is when they filed that thing. And then this other notice, wait a second, now we've got to look at this other notice. Hang on. The notice that there are no other docketed deficiencies. What? So he is saying, if I've got this correctly, please take note that as of October 10th, 2019, there are not any notice deficiencies on the docket for the above referenced matter. And then that's it. That's just a blank document here. And so what he's saying, I guess, is that the docket that I was just showing you, the judge signed that order on October 4th, but it didn't get docketed until October 10th. So how is Richard Liebowitz supposed to comply with it by October 10th if he's only receiving it on October 10th? So that's weird. Tactical, do you have an update from any of the other cases?
I have a notice in the Mazzy versus Mythical Entertainment that should be uploaded now.
Did you say Mythical Entertainment? That's Good Mythical Morning.
Yes, that is Good Mythical Morning. Yes.
There was a lawsuit against
Oh,
them?
really?
I kind of want to hear this.
I'm glad you know that. Well, that's what we've been reading. This is the Liebowitz lawsuits. He's filed a lawsuit against them as well. Let's find what's the docket number. I'll pull it up, or if you just want to throw the latest amended complaint or whatever in there. I guess there's not an amended complaint. It's just a regular complaint. We're not even done going down the rabbit hole with this story yet.
Okay, hold on. So can I clarify the notice of no more docket deficiencies? Is that basically notice that I'm following the rules, or notice that the judge is following the rules?
That's the notice that Liebowitz thinks he's following the rules in the analytical grammar case. We had looked at a couple. There were 3 cases there, so maybe the judge didn't list a deficiency in analytical grammar. Let's take a quick look while Practical is looking that up. We've got a Massey case. Yeah, here's the Massey case, right? That's not analytical grammar. And the Sands case is not analytical grammar. So there's Sands, and then here's Sands. So yeah, it appears that the only deficiency was the failure to pay the fee, and I don't know what's going on with his pro hoc vice. I don't see an appearance in that case, so I don't know what's going on there. Notice of special appearance. Dan Booth is representing the defendant in Bradley versus Analytical Grammar, and I believe we have heard from the Analytical Grammar defendant, so we might be able to do some kind of interview or follow-up on how things are going with the Analytical Grammar defendant. I will try to arrange that for this week. All right, here's the notice of cured deficiencies. We'll go over the complaint in a second. Here's the notice of cured deficiencies that he said that he has now cured everything in this action, looking at the docket, and he's asked for more time to file his entry of appearance, which is weird. He is saying, well, wait, there's a new, so they refiled the complaint, it looks like. That's what I would think this entry would be here. They refiled the complaint. They made the financial disclosure statement, and he's asking for additional time to comply with the rules for entering his appearance. Now, I'm really seriously building up to something here, because there's actually more to this. When you enter your appearance pro hoc vice, you're supposed to follow civil rules. And you go on a court's website. Here's the California Northern District website that says that to be admitted pro hoc vice, which means for this time only, you submit your application electronically through the CMECF system. You pay a fee via pay.gov. Must be accompanied by a cover letter if you cannot electronically file. So you register as an electronic filer. You download the application for Pro Hoc Vice, which looks like this. It's literally like a form. You just fill it out. You have to have local counsel. So that's a requirement. You always have to have local counsel. You have to be a member in good standing. You have to attach your certificate of good standing, and you have to agree to familiarize yourself with the rules of court. So that should be something easy for Richard Liebowitz to do, right? But I mean, come on, you know where I'm going with this. If I'm telling you that there's a Northern California Pro Hoc Vice procedure, maybe I just happen to get at something is happening in Northern California as well. So here's Northern District of California in the matter of Richard Liebowitz. Like, it's not even a single case. They've opened a separate miscellaneous case number just for Richard Liebowitz. To be eligible for admission to and continue membership in the bar of this court, an attorney must be an active member in good standing of the State Bar of California. This is normal. I'm an active member in good standing of the State Bar of Pennsylvania. An attorney search of the State Bar's website indicates that you, Richard Liebowitz, are not an active member of that California bar. Consequently, you are ordered to show cause before October 4th why your membership in the bar of this court should not be terminated. If you fail to file a timely and adequate response, you will be removed from the membership rolls without further notice. Now, I don't know, was he on the membership rolls somehow? I don't know. I think they mean that he filed the CMECF form before he was authorized to. Let me go over it. If you have exercised or pretended to be entitled to exercise any of the privileges of membership in the bar of this court, when you are not, in fact, entitled to exercise such privileges, you may be additionally referred to the Standing Committee on Professional Conduct for possible sanctions for unauthorized practice of law. It is so ordered, James Donato, United States District Judge, September 20th, 2019. So then, Richard Liebowitz responds, and he says, Richard Liebowitz, being duly sworn, respectfully submits the following response. My membership in the bar of the United States Court for the Northern District of California should not be terminated because, pursuant to the local rules, I have obtained local co-counsel on the plaintiff's behalf to file a notice of appearance in every pending case, which I have initiated. I have already filed an application for pro hoc vice in all pending cases before this court. My co-counsel has been designated and will file a notice of appearance within no later than 30 days of the granting of said application. I'm pretty sure that's not how the rule was written, right? It says here, you must register as an ECF user, download and fill out the form, e-file the application. Your authorization to practice begins upon the docketing of the judge's order granting your application. Following admission, all papers submitted for filing shall include appearance pro hoc vice immediately following the attorney identifying information. So the proper procedure, I mean, it just feels really stupid. Like, I mean, this guy has filed so many more lawsuits than I will in my entire life. And I feel like I've got a better grasp of how this is supposed to be done than he does. But seriously, this is simple stuff. The proper procedure was to have his co-counsel file the complaint instead. Then he enters his Leibowitz's appearance pro hoc vice via this procedure. Then it gets approved. Then he can file things. You don't file things until you are admitted. Not, I'll file them and the court will tell me what I did wrong and will tell me to fix it by a certain date. So the courts in California were not very kind to him because he was ordered disbarred. I know. Boom. But this is not that kind of disbarment. This is more so a prohibition or a disbarment from the Northern District of California, where he wasn't barred in the first place. And if he gets some kind of disciplinary complaint or something, yes, all of this will come into it, and maybe he'll be reprimanded. I doubt he will actually be disbarred from the state of New York or wherever else he's licensed to practice. But this would be a formal disbarment from practicing in the Northern District of California, and I'm guessing that doesn't affect his ability to get local counsel and pro hoc vice in. Now, another common way I see these kinds of copyright troll cases being done that don't get in trouble, I mean, Malamedia and Strike 3 Holdings, I would love to see them stop filing these cases. But the proper way to do this is to have your local counsel do all the local work. You can still act as a consultant or act as co-counsel that isn't appearing. And if you really want to appear, why do you need to appear anyway? It's like an ego thing sometimes, right? Like, I want to have my name on all these cases. Just have the local counsel do all the appearances, and then if Richard Liebowitz has to appear to support the case for some reason, then have Richard Liebowitz pro hoc vice in at that time. What's the big deal? So then the judge repeats, to be a member of the bar of this court, an attorney must be an active member in good standing. An attorney search on the State Bar of California's website indicates Liebowitz is not an active member. Leibowitz's response is not responsive and does not say anything at all about his membership in the State Bar of California. Well, I mean, it does say that he intends to get local counsel and have them enter his appearance. He just did it in the wrong order. He states that he has obtained local co-counsel, but that is not sufficient. The court consequently orders Richard P. Liebowitz removed from the membership roll of the bar of this court. In addition, Attorney Liebowitz is ordered to disclose these order to show cause proceedings to any judge in this district before whom Liebowitz has a pending pro hoc vice application. So that also doesn't say what's going to happen to him, but he is definitely forbidden from appearing in those cases until he solves this appearance problem. So if you are an attorney or a law student, or even if you're hiring an attorney, you should know that there are rules about how they have to enter their appearance. When my clients call me and say, I'd like you to represent me in, say, New Jersey, I inform them that I use local counsel in New Jersey and that I will be happy to adjust their fee to make sure they're not getting like double billed or something like that. We definitely don't double bill, or even in the sense where, like, if you have local counsel, what happens if the local counsel is working on the case and the lead counsel is working on the case? Are you getting billed for both attorneys at the same time? Yes. So, I pledge to limit that for my clients. Like, we're only going to use local counsel for the local stuff, and we're only going to use me for the, higher level, like, copyright stuff, rather than both at the same time. But there will be eventually a court appearance where both have to appear at the same time. And then, yes, we're going to have to either adjust the billing or not double bill as in the illegal sense, but yes, you'll get billed for each attorney, which can feel an awful lot like double billing. So, does this mean that all those defendants are off the hook? No, unfortunately, not yet. We're waiting to see whether these cases get dismissed by the judges. The case and the plaintiff's case can still proceed forward. It's the attorney that's screwed up. So the judge could easily just remove the attorney from the case and make sure that the plaintiff is using their local counsel instead. Or the plaintiff can go get a different attorney to enter their appearance. Or maybe Liebowitz can fix the problem and the judge will grant him pro hoc vice admission after all, after he finally files all the right paperwork. I would expect the judge to allow him to cure the deficiency if it was his first time, or maybe even his second or third, or once in a while mistake. This is presenting an odd case because normally you don't have all this other stuff going on where someone's filing mass litigation around the country and breaking rules, at least lighter rules. I don't mean that they aren't true rule violations, and they don't mean anything. They do. They mean a lot. Discovery violations cost a lot of money and time and effort, and they're a pain in the butt. But he's not lying under oath. He did sign the one form, right? Wasn't the one thing about forging a signature on a form? That's pretty bad. So there's got to be something coming down the pipeline for this guy for doing these cases this way. If you want to do cases like this, you can do them. You just got to follow all the rules, which means using your appropriate amount of time for each case. If you don't have enough time to follow the rules, then you don't have enough time to file this many cases, and you got to hire somebody else. Richard Liebowitz should hire another attorney to handle the overflow of cases that he can't handle. I think he might, I'm just speculating here, he might have a little bit of an ego problem where he thinks that he has to do it all himself. I'm not unfamiliar with that, hence I'm the jack of all trades, master of none, who tries to do everything himself. So I feel for Richard Liebowitz in that sense, but I'm on the flip side of this. Like, I would have done all of those things the correct way or not done them at all. Genuine mistakes can be forgiven. This is more than genuine mistakes. This is doing too much. So Richard Liebowitz has sort of been disbarred, and that's kind of fun. In the education sense, I don't mean like we want people to be disbarred. We want attorneys who are not doing their jobs properly to be disbarred. However, this attorney is scared that an overzealous court might disbar somebody for nothing. This is not that kind of disbarment. This is he didn't follow the rules and is trying to practice law in a court system where he didn't follow the rules and enter his appearance properly.
I think it also helps explain to people why lawyers sometimes charge a lot of money for what on the outside appears to be something very simple, where, you're just filing a complaint. People are like, oh, well, why does it cost so much money to do that? And part of that is because before you file a complaint, well, you got to check so many rules, and you have to make sure that you're doing it properly, because there's a lot of ways that you can mess up. And it's important to make sure that you've gone through everything on your checklist. And if you're filing a lot of cases, occasionally you're going to miss something or do something out of order. And if you're filing a lot of cases, that can add up to a number of cases at once that are deficient.
So what do you think of that story? Liebowitz got disbarred, but not disbarred. And maybe Richard Liebowitz isn't the most trolly copyright troll. He's more so a copyright troll for taking on too many cases and not being able to handle them competently and follow the rules like all of us are supposed to. So that's our show. Thank you very much for joining me. I am Leonard French, your favorite copyright attorney. Thank you very much to our supporters. This channel would not be possible without your support and sponsorship. Thank you to our supporters on patreon.com/ljfrench and sponsors.com/law. Thank you very much to our October supporters and sponsors. Thank you to Joshua Davis and TandaPay for sponsoring us in the month of October. Thank you to the $50 plus supporters in October: Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, who I think is in our audience right now, Daniel Perez, Snorre Wisotzky, Blackleaf, and Benjamin Hitov. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me and will be in the crawl in front of me for the outros of the video. I am Leonard French, your favorite copyright attorney. Thank you for joining me. I'll see you in the videos that drop. Love you all. Bye.